Okay, next we're going to move on to a couple of other issues that are relevant to limited partnerships. Now, the truth is that a lot of these issues are relevant to all types of partnerships, but we're discussing it in this chapter. First of all, the issue is something considered foreign or domestic? Now, you may say, well, who cares whether it's foreign or domestic? And the answer is that foreign companies have certain tax requirements and certain reporting requirements and all that, so very often it is important to make a determination as to whether an entity is foreign or considered domestic, which means, of course, subject to the laws of the United States. Well, even foreign companies sometimes are subject to the laws of the United States, but where is the central location of the company considered? And in this context, we're talking about both uh, inside the United States versus outside the United States, and also within various states. A limited partnership that's filed in New York, for example, would be considered for this purpose a foreign limited partnership in the state of New Jersey. So we're talking about both within the United States versus with outside the United States and states compared to other states. And under the Uniform Limited Partnership, there is a very simple, very logical rule. The laws of the state in which your entity is organized governs its organization. So if you file in Delaware, your limited partnership is subject to Delaware laws, even though you may never have been to Delaware. Many people do file in Delaware because Delaware's got favorable rules regarding corporations and regarding limited partnerships and LLCs. The fees structure is a little bit different, so many people file in Delaware, and therefore their companies are subject to the rules of Delaware, even though the business may have nothing to do with Delaware. And the certificate of registration would be the thing that's filed in Delaware that makes it subject to Delaware rules and that makes it a Delaware partnership, for example. As we discussed before, the key distinction between a general partnership and a limited partnership is based on the idea of liability. The general partners, even in a limited partnership, have unlimited liability. These are the people who are comparable to the partners in a general partnership. These are the people who run the company, and they have got unlimited liability, which means they are personally liable if the company gets sued, if the company commits a tort, or if the company gets subject to some sort of a judgment. The limited partners are only liable up to the amount of their contributions. That is the maximum that they can lose, but by the same token, they give up their right to control and manage the company. Only the general partners have the right to share in the management and voting rights in terms of how the company is managed. What can a limited partnership? What can a limited partner do and not lose his or her limited liability? Now, if you have a limited partner and it turns out that that limited partner is running the show and that limited partner is really acting as a general partner, then a court might say this person really is a general partner and lose his or her limited liability. However, you can have at least some element of management of a limited partnership and still be considered a limited partner. In other words, what can you do? You can be an agent of the limited partnership. If you're a limited partner and the general partners appoint you as an agent to do something for the company, that's okay. You can still be a limited partner. You can also be an employee. You can also be a contractor for the limited partnership. And of course, you can be a general partner, but then if you're a general partner, obviously you lose your limited liability. I'm going to write that over here, but then you lose the idea of limited liability because then you're a general partner, not a limited partner. And of course, you can also be a consultant or advisor. Just because you're hired by the general partners, you just can't have a voting right. In other words, you just can't be the person that actually is fundamentally in charge of managing the company. If the people that do manage the company, in other words, the general partners, appoint you as an employee or as an agent, that's fine. You can act as a surety, in other words, as a guarantor for loans that are taken out by the company. You can approve or disapprove an amendment to the partnership agreement. That's not really considered management of the company. And voting on certain specific partnership matters. Really, what you can't do is be somebody who is in charge of the day-to-day operations of the company and is the person that has the final say on these matters. And what this means, what the result of this is that limited partners, of course the general rule, are not individually liable for any debts that are owed or torts that are committed by the partnership. There are some exceptions. If the formation was defective, in other words, the proper documents weren't filed, well, then everybody has unlimited liability because now it is not a valid limited partnership. If you participate in the management, you can then lose your status, as we discussed before, as a limited partner. And also, even if you are a limited partner, if you make a personal guarantee on a loan taken out by the partnership, let's say, well, then you'll be personally liable. Just like if you weren't a partner and you made a personal guarantee, you would be liable for the repayment of that amount. Dissolution of a limited partnership is somewhat similar to a general partnership, which we covered before. It could be at the end of the life of the limited partnership if the time span is specified in the certificate. A partnership can be dissolved with the written consent of all general and limited partners because of the withdrawal of a general partner. Remember, with a general partnership, any partner that withdrew dissolved the entire thing. A limited partnership, on the other hand, it has to be a general partner that's withdrawing. If it's a limited partner, in other words, an investor that's withdrawing, that does not automatically cause the entire partnership to dissolve. And finally, if there's a decree of judicial dissolution, in other words, if a judge orders it to be dissolved for whatever reason, either because one of the partners brought an action or for some other reason, a judge can order the partnership dissolved. When you wind up a limited partnership, the default rules are pretty similar to what we discussed before regarding a general partnership. You have to wind up upon dissolution, file a certificate of cancellation with the Secretary of State. In other words, when you established the partnership originally, you had to file a certificate with the state to establish that you had a limited partnership, maybe pay a fee. So the same thing is true. When it ends, you have to file a certificate of cancellation. A general partnership doesn't have to do this because a general partnership doesn't have to file a certificate in the first place, but a limited partnership does. And as far as distributing the assets, these after these, well, if there are assets, then they have to be distributed. And the Revised Uniform Limited Partnership Act provides this preference order. First, you have the creditors, then the partners with respect to unpaid distributions. In other words, if there was supposed to be a distribution and one partner never got his or her distribution, that becomes the first thing paid out, then capital contributions, then the remainder of the proceeds. Essentially, these are the same rules as we discussed when we discussed the general partnerships.